Honorable Judges of the Court of Common Pleas in and for the County of Montgomery here holding this day. Let them come forth, appear, and they shall be heard. God save the Commonwealth and this honorable court. The Honorable Bernard A. Moore presiding. Court is now in session. You may be seated.
Counsel, the court has the matter of missing persons in Claiborne on its docket this afternoon. Would the plaintiff be prepared to make an opening statement regarding this matter this morning?
Yes, Your Honor.
Very well. Why don't you proceed?
Good afternoon, Your Honor, ladies and gentlemen of the jury. My name is Julie Allmeyer, and here with me today are my co-counsel, Rosanna Tormina and Kristen Ritter. Together we represent the plaintiff, Terry Fink. The case that you will hear today involves a fire that destroyed my client's business, Fink's Auto Body Shop, on the evening of August 7th, 1993. A fire that was started by that young man, Darrell Claiborne. Now this case is a little complicated to this extent. The name of the defendant is Lynn Claiborne, who is the parent of Darrell Claiborne, and is therefore legally and financially responsible for his actions. But it's Darrell Claiborne's negligence that is the subject of this trial. Now this is called a bifurcated trial. That means we are only concerned today with liability, whose fault it was, and not the resulting monetary damages. So we won't be specifying how much money you should award Mr. Fink. What we will do is show you that the fire started because of Darrell Claiborne's carelessness. Here is what the evidence will show you. At approximately 7 o'clock p.m. on August 7, 1993, Darrell Claiborne and 3 friends arrived at Fink's Auto Body Shop to go skateboarding on the small hill or incline directly adjacent to Fink's garage. Now, Mr. Fink was not at the shop at this time. Nobody was, since the shop was closed and everyone had gone home for the day. One of those skateboarders was Darrell's friend, Tracy Attila, and she will tell you what happened. Mr. Fink's property, which includes both the shop and the hill, was surrounded by a locked fence which Mr. Fink had put up to keep out unwanted visitors like Darrell. Mounted on the fence was a sign that said no skateboarding permitted. Disregarding both the fence and the sign, the group entered by crawling through a small hole in the fence. At this point, Darrell began with his first skateboard run down the hill. Right then, on that very first skateboard run, Darrell lost control and fell off his skateboard. His skateboard flew into the air and then went crashing through the side window at Fink's garage. Frightened by what Darrell had done, the teenagers all fled the scene. Now at this point, we have no further eyewitness testimony about what started the fire. What we do have is scientific, forensic evidence that has carefully reconstructed what happened. Blaze Weed, the Centerville Fire Marshal, investigated the fire and rendered a report. You will hear that Fire Marshal Weed concluded in his report that the most probable source of the fire was the combustion of fumes from paint cans and cleaning products, both of which are ordinarily used in a paint shop. And we will show you that this combustion occurred when Darrell Claiborne's skateboard shattered the window, flew into the building, and knocked over paint cans and cleaning products, causing flammable liquid to spill out and its fumes to come into contact with Mr. Fink's baseboard heaters. There will be no question in your mind that it was Darrell Claiborne's skateboard that started this fire. In fact, you will hear that Fire Marshal Weed agrees with us. He will tell you that a skateboard was found lying right there next to the overturned paint cans. He concluded that the skateboard played a likely role in starting the fire. When Mr. Fink comes to the stand, you will hear what he went through as he stood by that dark August night and watched 5 years of his life disappear in flames. After you've heard all the evidence, the judge will instruct you in detail about the legal definition of negligence. You will see that Darrell Claiborne was skateboarding negligently that day. His negligence was the proximate cause of the fire at Fink's garage, and that under the law, Darrell's parent is liable for the damages incurred in this fire. Members of the jury, please listen carefully to the testimony presented to you today. The evidence will show that Darrell Claiborne's carelessness set in motion a tragic chain of events that, in the end, cost my client, Terry Fink, his livelihood. After you've heard all the evidence, we will ask that you find in favor of Mr. Fink and let him start rebuilding his life. Thank you.
Thank you. Would the defense like to make an opening statement at this point?
We would.
Why don't you proceed, counsel?
My name is Ryan Tolan, along with my co-counsel John Kralovich and Thomas Gogol. We represent Lynn Claiborne and Darrell Claiborne, sir.
Very well. Why don't you proceed with your opening remarks to the jury?
Good afternoon, ladies and gentlemen of the jury, opposing counsel. As plaintiff counsel has already alluded to, we are here because on the night of August 7th, 1993, an unfortunate incident took place, a fire at Mr. Fink's auto body shop. It is regarding this fire that we are here. We intend to show that there is no direct causal connection between the actions of my client as being the proximate cause of that fire on that evening. We intend to show that there's a continual pattern of negligence on the part of the auto body owner himself, Mr. Fink, and it is this negligence that led to that fire on that evening. We will call Darrell Claiborne to the stand. When Darrell Claiborne takes the stand, ladies and gentlemen, I ask you, please pay close attention to the responsible way in which he runs his life. You will hear Darrell say that there was no clear, explicit prohibition that he did not belong on the premises that night. And you will also hear that there is a possibility that someone else was present in the auto body shop when Darrell's skateboard went through the window. And that same person is unable to produce their skateboard today. You will hear from the fire marshal, Blaze Weed. He will testify that Mr. Fink was cited 3 times by the Department of Environmental Resource for having paint cans too close to a heating element. And on the night in question, this same pattern of negligence continued when he had paint cans, newspapers, cleaning products, and 2 fully fueled cars in his paint shop. When Mr. Fink takes the stand, ladies and gentlemen, I ask you to remember, we are going to call into question Mr. Fink's motivation. Because here's a man that took money from 3 of the 4 parties that were present that night to relinquish them from all liability. And finally, Tracy Attila. Please, ladies and gentlemen, remember, Tracy cannot produce her skateboard either. And there is a possibility that she was in the building because as the night's events unfold, her whereabouts change. Ladies and gentlemen, this is a negligence case. Negligence means that there's a standard of conduct to conform to. We maintain that Mr. Fink did not conform to this standard of conduct. Mr. Fink's carelessness is the proximate cause of the fire. The evidence will show that Mr. Fink's own negligence is the cause of this fire. As a matter of fact, Mr. Fink has been building a tinderbox. He has been stirring up a recipe for disaster, and unfortunately, his irresponsibility brings us to court today. When all is said and done, ladies and gentlemen, you will find that Terry Fink, and not Darrell Claiborne, is responsible for the fire that took place on the night of August 7th, 1993. Thank you.
Thank you. Would the plaintiff like to present some evidence?
Your Honor, sure. If plaintiff rises, I would ask that the defense have permission for you to read some stipulated facts to the jury at this time.
Is there any objection to the plaintiff?
Yes, Your Honor. There are certain stipulated facts that we have stipulated to, but we don't feel are relevant. So,
If I may respond, Your Honor.
Sure.
The rules of this competition for the state, the stipulated facts may be read at any time of the proceeding, just like we begin reading out the brief that this opposing counsel has already stipulated are true. These are not disputed.
Well, at this point in time, I see no harm in having the jury made aware of the certain stipulations, so I'll give the defense leave to do that.
Thank you, Your Honor. Ladies and gentlemen, jury, these are stipulated facts which both plaintiff and the defense have agreed, and there was no debate over the facts that I'm about to present to you. First, Fink's Auto Body Shop was cited by the DER on July 6, 1993 for having flammable paint products too close to a heating element. Second, Mr. and Mrs. Zachary Attila paid to Fink the sum of $250 and they were forever released from liability with regard to their child, Tracy Attila, being present on Fink's property on August 7, 1993. Mr. and Mrs. Kirby Meyer paid to Fink the sum of $250 and they were forever released from liability with regard to their child, Charlie Meyer, being present on Fink's property on August 7, 1993. And lastly, Mrs. Angela Scott paid to Fink the sum of $250 and they were forever released from liability with regard to their son, Pat Scott, being present on Fink's property on August 7, 1993. Thank you.
Very well. Would the plaintiff like to call the first witness?
Yes, Your Honor.
Sure.
The plaintiff calls Terry Fink to the stand.
Very well.
Your Honor, as the witness is walking to the stand, I'd like the record to reflect that I am going to hand opposing counsel a copy of the civil review.
Very well.
State your full name.
Terry Fink,
Spell your name.
F-I-N-K.
Will you tell the truth, whole truth, and nothing but the truth?
Yes, I will.
You can be seated and you may stop.
Mr. Fink, do you go by Terrence or Terry?
Terry's fine.
Okay, where do you live?
I live at 1820 Fiddler Road in Centerville.
How old are you?
I'm 25.
What do you do for a living?
Well, until the fire occurred on August 7, I owned and operated Fink's Auto Body Repair and Paint Shop.
Okay, let's briefly discuss your background. Did you go to college?
No, I didn't.
Did you go to high school?
Yes, I graduated from Vista County Votech School in 1985.
And what did you do after that?
I worked at Umlauf's Ford Mercury in Centerville.
What did you do there?
I worked in the body and paint shop
How long did you work there?
for about 2 years.
What did you do after that?
Well, I decided to venture out and start my own business. That was Fink's Auto Body Repair and Paint Shop.
Prior to August 7th, for how long was your business in operation?
Well, we opened in '88, so for about 5 years.
Can you tell us a little about your business?
Well, I run the business. I have 3 people that help me in this. I have 2 people who work in the body and paint shop, and 1 person that serves as a secretary and bookkeeper. Now we do paint jobs and body work for people who want collision repair and custom design. And my business is located at 521 West Palm Street.
Can you tell us about the physical layout of your garage?
Well, it's a 1-story building. It's in 3 sections. The first 2 on the left are the original building I later had an addition built on. Now the one on the far left, that was the customer service area. To its immediate right, there was an auto body shop. They were made mostly of wood, and that was the original building, as I said. I later had an addition built on to the right-hand side of the auto body shop, and that was the paint shop. That was mostly concrete construction.
Can you tell the jury about the ground on which your garage was located?
It's basically flat terrain. Once again, if you're facing the front of the building, on the far right, there's a hill that leads up to the paint shop.
Is there a door or window facing the small hill?
Yes, there's a window in the paint shop.
Is this hill included on your property or on a neighboring property?
It's on my property.
Terry, is there anything enclosing your property?
Yes, I got concerned about unwanted visitors and trespassers on my property, so I built a fence on July 2nd, 1993.
And why did you put that up?
I wanted to keep out unwanted visitors and trespassers.
Terry, did you do anything else to keep out unwanted visitors or trespassers?
Yes, I was most concerned about people skateboarding on my property, so I put a sign on the fence that said no skateboarding permitted. I put that on when the fence was done, July 2nd.
Okay, when was this date in relation to the fire?
More than a month beforehand.
Terry, did the fence and the sign seem to keep the skateboarders out?
As far as I knew, once the fence and the sign were up, there wasn't any skateboarding on my property.
Okay, Terry, after the fence and the sign went up, did you ever consent to the use of your property by any skateboarders?
No, I didn't.
Okay, Terry, let me direct your attention to August 7th, 1993, the day of the fire. Was that day a normal business day?
Yes, it was.
What's the last thing you did before you left that day?
Well, I closed the shop at 5 p.m., and then I closed and locked the gate on the fence as I left.
Terry, when did you find out that your garage was on fire?
At 11:50 that night.
And what did you do at that time?
Well, I jumped in my car. I wanted to get to my shop as quickly as I could.
When you got to your garage, can you tell us what you saw?
I saw my garage in flames. It was burning to the ground when I got there.
Did you see anything that gave you any indication of what started the fire?
Well, first I saw soda
Objection, Your
cans.
Honor.
Counsel, what's the basis of objection?
Your Honor, counsel is asking the witness to draw a conclusion as to how the fire started.
Counsel, do you care to respond to
Your Honor,
opposing
I-
counsel's objection?
I will move on.
Very well.
Terry, after the fire was extinguished, did you find out the extent of the damages to your garage?
The whole building was destroyed.
After the fire, were you able to open up for business at any point?
The fire was so extensive, it put me out of business. There wasn't anything left to open up.
Terry, to your knowledge, was the fire ever investigated by any municipal authority?
Yes, Fire Marshal Weed was on the scene that night. I knew that he conducted an investigation of the fire.
Do you know if he ever prepared a report of that investigation?
Yes, he did.
And are you familiar with the findings contained in that report?
Yes, I am.
Your Honor, may I approach the witness?
Sure.
Let the record reflect that I am handing the witness what is marked as Exhibit 1. It is labeled across the top, Blaze Weed, Fire Marshal, City of Centerville, Pennsylvania. Your Honor, this copy.
Sure.
Opposing counsel has already given a copy.
Very well.
Terry, can you identify this?
Yes, this is the expert report done by Fire Marshal Weed. It's titled Fire Fink's Garage, August 7, 1993.
And what is the date on that report?
September 8, 1993.
Terry, is there any information in this report that you relied upon in bringing this claim against Darrell Claiborne?
Objection, Your Honor. Your Honor, counsel is asking the witness to testify in a report that he did not prepare, and in fact, this is hearsay testimony as he's testifying.
Counsel, do you care to respond?
Your Honor, this is an official record and therefore an exception to the hearsay rule.
I mean, this report has been stipulated, hasn't it?
The authenticity of this report, yes, has been stipulated, but we still feel...
And this witness is simply being asked what he did after he reviewed the report,
Yes, Your
essentially.
Honor. He simply asked, I'm asking to restate information from this.
May I respond, Your Honor?
Sure.
I feel that counsel, the defense counsel feels that's an appropriate question for the fire marshal to actually prepare the report. But to have this witness present to talk about the contents of the report which he did not prepare, I feel is hearsay testimony.
Your Honor, may I-
Sure.
Your Honor, I'm simply asking the witness to use this report to restate information that will explain to the jury why he is suing Darrell Claiborne.
Well, for that purpose, I'll allow it, particularly since it's a stipulated document. Proceed.
Terry, I'll ask you again. Is there any information in this report that you relied upon in bringing this claim against Darrell Claiborne?
Yes, there is.
And what information is that?
Well, first of all, in the first paragraph of the conclusion section, it says that the most probable cause of the fire was the combustion of fumes from open paint cans and cleaning products. Second of all, in that same paragraph, it says that a skateboard played a likely role in that ignition. And third, in the fifth paragraph of the findings section, it says that a charged skateboard was found right there on the scene.
Terry, why are you suing Darrell Claiborne for the losses you sustained in this fire?
We know Darrell was skateboarding on my property that night. And we know that his skateboard went through my window into my paint shop where I store my paints and chemicals. We know that something knocked over and spilled those paints and chemicals, and we know that his skateboard was found right there on the scene. Based on this information, I think Darrell Claiborne started the fire.
Thank you, Your Honor. I have no further questions.
Thank you, counsel. Would the defense like to cross-examine the witness?
Just move, Your Honor.
Why don't you proceed?
Thank you. Mr. Fink, the fact that kids were skateboarding on your property was nothing new, was it?
No, it wasn't.
In fact, kids have been skateboarding on your property for the past couple of years. Is that not so?
That's right.
Mr. Fink, didn't they not do so with your permission?
I never actually said to them. I occasionally watched them skateboard.
Oh, you occasionally watch them skateboard. Isn't it true, Mr. Fink, that you state that you like watching them show off their fancy techniques?
Yeah, I thought that was really neat that kids could do stuff like that.
Mr. Fink, one day you decide that you are responsible for these children on your property, so you decide that they can no longer use it, correct?
That's right.
Now, Mr. Fink, these children who have been skateboarding on your property for years, did you ever explicitly tell them that they were no longer allowed to use your property for skateboarding?
I thought the fence and the sign would be sufficient.
Mr. Fink, please answer my question. Did you ever explicitly tell them, no, don't use my property anymore?
No, I didn't.
So, Mr. Fink, you decided, as you previously stated, to build a fence, correct?
Excuse me?
As you previously stated, you decided to build a fence, correct?
That's right.
This wasn't a new fence, was it, Mr. Fink?
It was new to my property.
Mr. Fink, isn't it true that you got the materials for this fence at a junkyard?
That's right. I was kind of frugal, and the prices when I priced out a fence, they were just too expensive for me.
Mr. Fink, did you have professionals help you to erect this fence?
No, I didn't.
In fact, you had a man by the name of Sam Enders help you to erect this fence. Is that not true?
That's right. He's an ex-employee of mine.
An ex-employee of yours. He's an ex-employee of yours, Mr. Fink. Is this not so? Because you fired him for being drunk on the job?
That's right.
Objection, Your Honor, relevant.
Your Honor,
Counsel, you care to respond?
yes, I would, Your Honor. We're trying to show the fence, the so-called fence which surrounds Fairfield property, in no way resembles a fence. It can be easily confused as any structure. And the quality of this fence is very relevant in this case.
Your Honor, I was just objecting to the use of Sam Enders. He has absolutely no relevance to the case.
Well, I'll give some latitude in cross-examination, plus the witness has already responded.
Now, Mr. Rubin, you state that this fence was completed on the 2nd of July, correct?
That's right.
And this great fence that you built, isn't it true that it started to come apart on the 6th of July, 4 days later? Yes or no?
Yes, I saw a small hole in it.
Mr. Fink, you totally forgot about this hole that day, didn't you?
Yes, I did.
You didn't repair it, did you?
No, I didn't.
And you stated in your affidavit that something distracted you that day, correct?
That's correct.
Isn't it true that the Department of Environmental Resources came to your property and cited you for having
Objection,
fled?
Your Honor. This line of questioning seeks information that is both irrelevant and highly prejudicial. And because of the nature of this objection, I ask that we handle it as if it were at sidebar. I know that we normally would be approaching the bench, but the mock trial rules.
Very well, we can
require-
consider this as a sidebar hearing at this particular point in time. Counsel, do you care to respond to opposing? Well, do you wish to elaborate on your objection?
Yes, Your Honor.
Very well, why don't we proceed, then we'll hear from opposing counsel.
The council is seeking to elicit testimony concerning one, if not three, prior citations that Mr. Fink was given concerning the improper storage of his paints and chemicals. Now, none of these citations are dated August 7th, 1993. In fact, the most recent one is a month before that date. The defense has to show that on August 7th, 1993, Mr. Fink was storing his chemicals in an improper fashion. Because they cannot show this using these citations, they are irrelevant and only serve to prejudice the jury.
Counsel, would you like to respond?
Yes, I would, Your Honor.
Counsel's objection.
Yes, I would, Your Honor. We are trying to show a pattern of negligence by the plaintiff in that not on one occasion, not two, but 3 occasions, he had paid case too close to the heating element. And it is very relevant considering the fact that the plaintiff has already brought up in his case that on the night in question, the fire was started most probably by knocking over the paint cans. And that's why we feel this is relevant testimony.
Very well, I'm going to, in light of the fact that we're dealing with cross-examination, I want to give some latitude to counsel over the objection.
Thank you, Your Honor. Now, Mr. Fink, the Department of Environmental Resources came and they cited you, this is not true, for having flammable paint cans too close to a heating element in your shop. Yes or no, Mr. Fink?
Yes.
Mr. Fink, was this the first time that the DER came to your shop?
No, it wasn't.
This is the second time that the DER came to your shop.
Yes, it was.
Excuse me, Mr.
Oh,
Fink?
I'm sorry, it was the third time.
Third time that the DER came to your shop. Is it true on all 3 occasions they cited you for violating the same offense?
That's right, and they haven't come and cited me since.
And Mr. Fink, isn't it true that you were fined $1,000 because this was indeed your third citation?
That's right, and that was quite enough to make me stop my ways.
Mr. Fink, you referred to the fire marshal's report in your direct examination. Isn't it true that in that very report, the fire marshal concludes that you had paint cans 3 feet away from a heating element, even after these 3 citations?
That's right.
Mr. Fink, isn't it also the case that on the night in question, you had cleaning products 3 feet from these heating elements?
That's
Objection,
correct.
Your Honor. This line of testimony also, everything that is contained in Fire Marshal Wheat's report is a report of what happened after the fire occurred. Fire Marshal Wheat states that none of these, they don't have to specifically have been placed there before the fire occurred. So this line of questioning does not have any relevance.
Counsel, do you care to respond?
Yes, I would, Your Honor. I'm not, when I asked about the cleaning products, I'm not citing from the fire marshal's report. We had pleadings before this case, Your Honor, where we say that cleaning products are 3 feet away from the heating element, and the plaintiff is admitted to that. And that's all I'm bringing out now.
Yeah.
I'm not talking about the fire marshal.
Well, I'd like to make it clear that the 3 feet away from the heating element was after the fire occurred. The fire marshal made it clear that this could have all happened as a result of the explosion, and we have no way of knowing where the paint cans were before the fire occurred. That's why.
Very well. I'll certainly give you latitude to argue that, including remarks to the jury, but for purposes of cross-examination, I'll give the defense some latitude. Proceed.
Mr. Fink, isn't it true that you had cleaning products? Is it true that you admit to having cleaning products 3 feet away from the heating element on the night of the fire?
Yes.
And is it true that you admit to having stacked newspapers that the fire marshal says fed the fire 1 to 2 feet from that very heating element?
Yes.
And isn't it true that on the night in question, Mr. Fink, you had 2 cars, 2 gas tanks in your paint shop?
That's true, that's what they're there for, to be painted.
Thank you very much. I have nothing further. Your Honor.
Very well, thank you, counsel. Sir, you may step down. Would the plaintiff like to present any further evidence?
Yes, Your Honor. Plaintiff calls Tracy Attila.
Very well.